Hear me okay? Great. Well, welcome to our session with the BII today. I'll tell you a little bit more about it in a moment, but just for some housekeeping, if you could put yourselves on mute if you aren't already, so that we get less background noise, I'd be very grateful. So we've got quite a few people joining us today, which I'm really pleased about. First of all, Catherine, my colleague, has got some slides. So if you could just share your screen, Catherine. Thank you. So just by way of introduction, my name is Jay Bayani. I'm a solicitor and managing director at Bayani HR and Employment Law, and we run the BII helpline. So we probably will have spoken to a number of you over the last couple of years. Certainly in the last year, we've been incredibly busy doing what we can to help you work through the minefield of furlough scheme, redundancy planning, and returning to work. And at the moment, that's really what we're concentrating on, is getting geared up for the 12th of April. So just to tell you a little bit about us, so we're a niche practice we're based in Sheffield, although we've got offices in London, Leeds and Leicester, and we work with lots of clients, hospitality clients in particular, but lots of other clients as well, looking after everything to do with their people management. Today we're here as the helpline providers for the BII, and I'd really urge you to use BII helpline as much as you can for the help that you need running up to opening and beyond. But if you need more than that, then we have a bespoke service that some of you I think are members of, and others may be interested in, called Watertight. But start with the BII because there's lots of free information that you can get. So I think we'll move on to the session. My colleague Catherine has put together some questions, so the sort of common questions that we're getting on a day-to-day basis. We've noticed that the helpline has really sort of ramped up again this week, so people are obviously getting geared up and being asked questions by their employees or anticipating that they will. I hope you find this useful. If you're familiar with Zoom, you'll know that there's a chat function at the bottom of your screen. So if you want to ask any questions as we go along, please do ask questions on there, and if not, we'll have an opportunity to have some additional questions at the end, but hopefully what Catherine's going to do will actually cover much of the questions that you'll be coming across. Okay, so Catherine, I'm going to leave you to kick off.
Okay, thank you very much. So as Jay said, we run the helpline, and so we thought it'd be quite helpful to go through a lot of the very frequently asked questions that we have on a daily basis, because we figured if a lot of people are already asking it, then they're probably questions that a lot of people are thinking about, including yourself. So we'll just go through them, and as Jay said, any questions that you've got throughout it, pop them in the chat and we'll try and answer them for you at the end. So the first one is the biggest one that we've really been asked of late. Can I force my employees to have the vaccine? You know, not just from a hospitality point of view, many other sectors are also thinking about this, whether or not you can mandate it. So the short question to that is, you can't force them to have the vaccine because you can't pin somebody down and make them have it. But what you may be able to do is take action against an employee who unreasonably refuses. Now, if you need to show quite a bit of caution about this, there's been nothing tested through the tribunal system. There hasn't been time yet for there to be, so we don't know how the tribunal system is judging these things. But what we would say is that you need to have some very strong justification. You need to have very strong justification as to why you would. You need to consider why the employee is refusing. So if an employee is refusing to have the vaccine and it's to do with, for instance, a disability, or it's to do with a religious belief, then you need to show a little bit of caution before you say they have to, because then you could get yourself into hot water to do with discrimination. What we're advising is to encourage all of your employees to be vaccinated, provide them with up-to-date, reliable information. You may want to consider giving them paid time off for vaccine appointments so that they're, that's not going to be a worry of theirs, that they're going to lose some money because of it, lose hours. And it's really more about encouragement. I think at this point, as the government are not mandating it, you'd really, really struggle to be able to mandate it, and to be able to discipline somebody for not having a vaccination safely is our view, really. And if you are doing that, if you are thinking about disciplining somebody for not having the vaccine, give us a call on the BII, because it really is quite risky for you to do that. Okay. Should I keep records of all the staff? So this is another one that we're asked a lot. And basically it's like you would do any sort of health records, things like that, a health questionnaire. Should you ask your staff to let you know when they've been vaccinated? So there's a few things you need to consider about this. From a GDPR point of view, this is classed as sensitive personal data. So you do need explicit consent for your employees to be able to hold this data. In order for you to hold the sensitive personal data, you need to be able to what's called objectively justify your reason for collecting it. And you'll all have your own reasons. I guess the main one is so that you know who's vaccinated from a safety point of view. But I was having a conversation yesterday with one of our clients, and she was wanting to gather all of the data. And my question to her was, well, once if you have got it all, what are you going to do with it? What's your reason for having it? I said, are you going to discipline people potentially for not having the vaccine? And she said, no, I'm not actually going to do anything with it. I just want to know. And it's like, well, if that's the only reason you're collecting it, why are you collecting it? If you're not going to use it for anything other than your own knowledge, why are you collecting it? So it's really about thinking very clearly about what your end result is going to be. Why do you want it? And then you can make a decision as to whether you're going to try and collect it. You need to think about whether you need to add it into your privacy notice that you have for your staff from a GDPR point of view. Like I said, you may need to gain their explicit consent. And as I said, you're going to have to consider how you're going to use it. And you also need to think about your data retention policy as well, in terms of all of the data that you hold on your staff. You're probably going to have to add it into that. Okay. How and when should I make people redundant? So obviously this is, there's been a lot of redundancies, unfortunately, over the last year or so, a lot of which we've been advising on, and it's really sad. But unfortunately, when you're running a business, sometimes you need to make these decisions. But the main questions that we get asked are how and when. So redundancies, they should always be well thought out and planned to make sure that the correct legal process is being followed. So there are some things held in statute and legislation regarding how you should approach redundancies, but they're really when they're large scale redundancies, when you're talking about 20 or more people. When it's less than 20 people that you're going to be making redundant in a 90-day period, then there isn't so much of a rigid process that you need to follow. Your process does, however, need to be reasonable, and it needs to be meaningful. And there does need to be a genuine business reason for the redundancy to be made. And one of the big pitfalls that we get, that we find, is that people don't really understand that it's a role that gets made redundant and not a person. And so we're often getting people calling saying, well, they're saying that they can't come in for shifts, and they're saying that they don't want to come back, so we're going to make them redundant. That would probably be deemed to be an unfair dismissal if they're your reasons for the redundancy. If there is a group of people in the same role, then you need to do a redundancy process on all of them and utilise a selection criteria. A failure to follow a fair procedure can lead to claims in the employment tribunal for unfair dismissal, wrongful dismissal, failure to consult, discrimination, pay claims. There are so many different claims that can come out of a redundancy procedure if it's done incorrectly. So we really, really do urge you to take advice if you are having to do a redundancy. When to make redundancies will be down to the individual circumstances of the business. And so you need to, but what we would say is don't leave it too late. If you know now that you're going to need to make redundancies, then don't drag it out too long, because then you might get yourself into a position where, from a business point of view, you've left it too late and you can't any longer afford to do it. So as soon as you know that you are going to have to make redundancies, I'd jump on that as quickly as you can. And again, from the BII, we can help with that. Can you force your employees to take their holiday before we reopen on 12th of April? And what are the rules with carrying over? So yes, you can force your staff to take holiday. You have that right as an employer, but you do have to give twice the amount of notice as the amount of holiday being taken. So you'll probably struggle to get much in now before the 12th of April, given it's only kind of a week and a half away, isn't it? But it's something you should definitely think about moving forward. If you force them to take annual leave, or if they request to take annual leave whilst on furlough, you do need to top their pay up to 100% for that day or for that week, whatever the period of annual leave is that's being taken. So you can still claim your 80% furlough, and then you just need to top it up to 100% yourself. So the working time regulations were amended so that employees can carry over any untaken annual leave for 2 years. And the reason for that, it's for people who were unable to take annual leave due to COVID. So it's not necessarily that they couldn't go on holiday and enjoy a holiday abroad. That's not a reason to carry over. When these regulations are for people like nurses, delivery drivers, doctors, people who've really been pulled out in their professional life and so haven't literally been able to take the time. It's not about whether or not they could go on holiday. So employees don't have the automatic right to carry that holiday over. It is up to you as an employer. And what I would say is, if you are planning on allowing people to carry holiday over, you need to be careful that you don't get yourself into a position where everybody's trying to take all the holiday at the same time. So if I were you, if you are, for instance, allowing them to take 10 days holiday and carry that over, and they're a full-time member of staff, so they're presumably using 5 days per week, I would be saying to them, well, you need to use one of the weeks in the first year and you need to be using one of the weeks in the second year. I'd put parameters in place for that in order to protect your business, and you're perfectly able to do that. But what I would do is do it right. I'd do it sort of right at the start of the holiday year, or even the end of the previous holiday year, just to make it incredibly clear so that there can be no equivocation moving forward. Everybody knows what those parameters are. And like I said, the purpose for the regs was not so that employees could carry over leave to take when things go back to normal. It was that they were genuinely unable to take the time. So if my employees have not taken their holiday before the end of our holiday year, do they automatically lose the rights to these? So yes, technically, if your employees have been given the opportunity to take their leave but have decided not to do this, then they lose it. You do have a bit of a kind of an equal obligation as your employee to ensure that that annual leave is taken, because it's rest time, and that's what the working time directive is for. It's to ensure that people have rest. And just because somebody's on furlough, technically it doesn't mean that they've had that rest, because they're basically on call while they're on furlough, because they should always be able to come back to work. So that's not technically rest time. And we really don't know how that argument would fly if you tried to, defend a breach of the working time regulations by saying, but they were on furlough, because it hasn't been tested yet. So what we always say is encourage your staff to take annual leave, and make sure you do that in some sort of written communication, so that if it does get challenged, if at any point they make a claim to say that you've breached the working time directive by not allowing them to take it, then you can say, well, we were encouraging people, we told people to take it. And if people really are not taking it, because we understand that employees at the minute don't want to because they can't go on holiday, you can force them, as I said in a previous question, as long as you give them twice as much notice as the amount of annual leave to be taken. You do need to bear in mind that there are some specific carryover rules. So people who are on maternity, for instance, or shared parental leave, or people who are on long-term sick, they do have the automatic right to have that carried over. So if at any point you're not sure, just give us a call and we can let you know. When my employees do pay over to a transferee, do they keep their holiday entitlement? So the answer to that is yes. So whatever the holiday year is in the normal terms and conditions, whatever they've accrued up to that point will transfer over to you. It's not that they lose that holiday. And then you need to honour that, because one of the basic principles of 2Pay is that you need to honour their terms and conditions. Okay. When 2Paid, can the transferee still furlough the employees? And just so you know, the transferee is the new employer, the transferor is the previous employer. So yes, as long as the employee was on the RTI and a PAYE before 30th of October of last year, they can still be placed on furlough. It's important to remember that post-transfer, if the employees have not been issued with a P45 in time, they may be subject to emergency tax. We get that question quite a lot, where people have been emergency taxed, and it's because the first employer, they have to finish them on their system. So although it's not a dismissal because it carries over to the new employer, they still need to finish them on their system. So a P45 is issued. And if it's not done in a timely fashion, then obviously the HMRC may assume that that person has got two jobs, one with the old employer and one with the new employer. So they'll be placed on emergency tax. So A, you need to make sure it's timely, and B, I would be also communicating with the staff that, you know, if there are any problems, that you'll work with them in terms of the tax code, because it might, you know, sometimes it just happens. It's resolved directly by the HMRC, and they will get that money back, anything that they've overpaid because they were placed on basic rate. You may want to consider whether you give them a bit of an additional payment to just tide them over that you can then recoup later down the line. Because obviously if people are on 80%, they might already be struggling, they might already be in financial hardship because of that, and a bit more tax paid might put them into more financial hardship. So it's just worth having that communication and having that conversation with them if you think it might be a problem. Can I amend my furlough claim once submitted? Once you've submitted it, you can't make any amendments to it or additional claims through the portal itself. You can, however, in some circumstances, call the HMRC helpline. The number is just there. And in some circumstances, you can amend the original claims or add on any missed employees or amounts not previously claimed for. And we have been told that for the most part, HMRC are being quite helpful about things like this. I'm taking over a business, but I do not require some of their employees due to having my own. So can I dismiss them? So no, you can't, just by token of the fact that you don't want them. It's fine to have a redundancy situation post-transfer, that is okay. However, you can't just dismiss somebody on the basis that they were the old staff and you want to keep your staff. Because if an employee is dismissed by either the outgoing or the incoming employer, before or after a transfer, and the only reason, so the sole or the principal reason, is the transfer, it is automatically unfair, and that's regardless of length of service. So the 2-year unfair dismissal length of service does not apply. Dismissals for ETO reasons may be fair if they fulfill the requirements. So if you do need to make changes after a 2Pay, you can, you just need to show an awful lot of caution. And ETO is economical, technical, or organisational. So arguably, in the scenario posed, that would be organisational because we've got surplus staff. So we need to reduce that headcount. But what you couldn't do is just sack the people who were with the previous employers. You would have to do a full redundancy process on all of them combined and make sure that you followed that fair process and didn't treat any of them differently. And if the reason for the dismissal isn't the transfer, it won't be automatically unfair, but it may still be an unfair dismissal if you haven't followed a proper redundancy or dismissal procedure. Okay. Because when it comes to unfair dismissal, I don't know if people know, it's not necessarily the reason for the dismissal that makes it unfair or not, it's actually the process and the procedure that you follow as an employer to dismiss. So when it comes to a redundancy, if it did go to a tribunal, the judge is likely not to even really pay much heed to your business reason. They will assume that there was a business reason for the most part. However, they will look at how you went about that redundancy, and that is often what renders it fair or unfair. So due to the pandemic, I want to put my employees on a fixed hour contract and vary their terms and conditions. How do I do this? Now, this is something you probably should all be thinking about. I know that you're going to be able to open on the 12th, but obviously, depending on the setup of your business, depends on what that trade level is going to look like. So moving forward, in order to maintain your employees in what's likely to be restricted circumstances, it might be worth asking them to vary their terms and conditions and reduce the amount of contractual hours that they do have. If you want to change an employee's terms and conditions, you need to inform and consult with the employee directly, or if it's more than a certain amount of people, you may need to get an employee representative to do a collective consultation, or if you've got union presence, you need to think about whether or not you need to get your union involved. We recommend you sit down with your employees, explain the changes, negotiate on these, and just be honest about why you need to do it. And in reality, for most of you, the reason you want to do it is because you want to be able to carry on employing as many people as you can. And you're going to want to avoid the need for a redundancy. So by them agreeing to do these things, you're going to be able to retain employment for as many of them as you can. If the employee agrees, then you'll provide a variation of contract letter. And it's just, that can be a very brief letter that just kind of says, this is what's changing, the rest of your terms and conditions will remain in place. And if the employee does not agree with the new terms, you may need to look at dismissing and re-engaging them on your new terms. Employees do sometimes ask for a trial period so they can kind of suck it and see how it suits them, and see if they're prepared to accept it. Accepting the terms during a trial period, however, is not the same as accepting permanently. And the employee, if you agree to a trial, can still refute the changes at the end of that trial period. Okay. What if an employer refuses the variation to contract? What do you do then? So if they refuse the changes, you can dismiss and re-engage on the new contract's terms in any event. It's then for the employee to argue that the new terms are unreasonable and unfair, meaning you effectively dismiss them. So what they would do is they would have to quit, and they would have to claim what's called constructive unfair dismissal, that you forcing unreasonable and unfair terms upon them meant that their position was no longer tenable, and so they had no option but to resign. So effectively, you have dismissed them. And when it comes to whether or not changes are reasonable or not, there's no black and white list on that, because all businesses are different, all the situations are different, everybody's contracts of employments are different. So there isn't a definitive list on what is considered to be reasonable and what is not considered to be reasonable. So again, call the BII, we can give you some guidance on that. Unfortunately, the only time there will be a definitive decision made is if it is challenged in the employment tribunal, and a judge would look at the whole situation, and they would make a determination as to whether that change was reasonable or not. So you'll never get a definitive answer until you're actually there at the tribunal, unfortunately. Often employees will have variations clauses within their contracts of employment, which do allow you to make changes. What I would say, though, is even if you have got a variations clause, that does not mean you can make any changes that you want. They still need to be reasonable. Okay, and they still also need to be within the boundaries of the Employment Rights Act and any statutory provisions that they may have in terms of holiday, sick pay, things like that. Okay. It's a difficult argument for an employee to claim constructive unfair dismissal, but if the change in the contracted terms is so different from the original terms, it might be considered to be an unreasonable change. So seek advice before you wanted to make any changes. It's not saying that you can't, but you should seek advice. So this was one we got just the other day. I made 9 employees redundant following the 3rd lockdown, but with news of reopening on 12th of April, these employees are claiming the redundancy was a sham, as we may need to recruit for the reopening. So as long as you can prove that at the time of the redundancy, you did not need these employees and you were not in a financial position to support via furlough, any claim for unfair dismissal would be difficult to make. The purpose of the furlough scheme is to protect employees where it is known their job will still exist in the future. At the time of making these employees redundant, if you can provide evidence to show you did not require their service and there was no envisaged return to work date, then you should be fine. It should be easily defendable. And don't forget, just because you've made them redundant, if you do require more staff for reopening, it doesn't mean that you can't re-employ them. So, you know, you can get back in touch with them actively if you choose to and say, look, you know, I know we made you redundant. Things have changed now. We've had a bit of an uptake. And so we're in a position where we can rehire. Do you want to come back? You're absolutely fine to do that. Can I reclaim notice pay during the time that somebody's on furlough? So this is whether you've given them notice or whether they have handed in their own notice. Can you claim furlough during that time? And the answer is no. So if somebody is on a period of notice, irrespective of whether it's them or yourselves that have provided that notice, you can no longer claim furlough during that time. So at first you could, and then I believe it was like the 10th of December last year that changed, and so you can no longer claim it. In terms of top up in pay, it's important to determine whether an employee receives statutory or contractual notice. So there is a little bit of a kind of a quirk in law. So the difference between statutory or contractual notice is that statutory notice is what is laid out in the Employment Rights Act as the minimum amount of notice you're allowed to give a member of staff. That minimum amount of notice is 1 week in the first 2 years, and for every full year afterwards, an additional week up to a maximum of 12 weeks. Contractual notice is what is held within their contract. Now, what you cannot do is in the contract have less notice than you're allowed to give by law, but what you can do is have more. So it's quite common, especially in the more senior positions, for somebody to maybe have, you know, as soon as they're out of the probationary period, they have a 3-month notice period. So obviously, if they've been there less than 2 years, then that's quite a large amount of time more than the statutory notice, which would only be a week. So if in your contracts you have got more than a week longer as the contractual notice as the statutory notice that they would have received, you can just pay them at 80%. So you can leave them on furlough. You wouldn't be able to claim that 80%, but it means that it's less for you to find. If, however, they have only got their regular statutory notice, then you would need to pay them 100% of their salary. And don't ask me why. I've asked a lot of employment lawyers why. No one can really give me an answer, but it is what it is. It is a little bit of a mind bender, that one. So if at any point you're not sure whether or not that will apply to you, just give us a call and we can talk you through it. Okay. Can I host a wedding of 30 people from the 12th of April? So no, you can't. From the 12th, for now at least, up to 15 people will be allowed to attend a wedding ceremony and reception. And it's also important for you guys to remember that they can only take place in places of worship, public buildings, and in locations that are already permitted to open with outdoor receptions only. Okay, so make sure that you don't agree to a wedding when you're not technically allowed to. What happens if the government change their mind 1 week before we are due to reopen on the 12th of April? I think everybody across the land is hoping that this won't happen. You know, I've got a table booked for the 12th of April and I'll be very, very disappointed if I can't make it after work. So before each stage of the roadmap, the government will review data assessing the impact of the previous steps against the 4 tests that Boris laid out for us. It may be that you need to place people back on furlough. So, you know, what I would be doing is communicating with the staff saying, right, you know, best case scenario, we're opening it on the 12th of April. This is, you know, this is what is going to happen. These are the risk assessments we've got in place. This is how we're keeping our place COVID secure, and all of that, just so that they've got all of that information. But I would also be saying that obviously that is all based upon government decisions, and that if anything changes, you'll let them know as soon as you possibly can, just to manage their expectations on that. But obviously you can place them back on furlough. If that delay is delayed even further, then obviously it might take you into the period where you're going to have to start contributing more to the furlough, to the percentages, that when you're not going to be able to claim the full 80% any longer. And so you really are then going to have to consider whether or not the delay in opening might require you to make redundancies. And as I've said before, give us a call and we can help you with that. Which employees should return to work first? This is a question that we get asked a lot. So it's unlikely all employees will be able to return to the workplace at once, because you're going to be, you know, restricted on the amount of trade you'll be able to do over the coming months. So you should consider what employees, departments, groups or units should return first based on the business need. Try as much as possible not to make it about people, try and make it about the business. Compliance with ongoing restrictions regarding limitations to essential business and compliance with health precautions such as social distancing should all be taken into consideration when you're thinking about how many people to bring back, sorry. And the legitimate business reasons for this selection process should be documented to provide evidence of non-discriminatory selection criteria if that is later challenged. And then what you also need to bear in mind is, whilst shielding came to an end yesterday, you know, you may have got people who have got those shielding letters who might prefer to be furloughed for longer if you can. So, you know, if they do request to stay on furlough for longer, if you're able to do it, that's absolutely fine. I know that the kids are now back at school. However, obviously, you know, whenever they need to sort of self-isolate because one of the little ones in the class is showing symptoms, there's still going to be some childcare issues. So it might be worth, you know, if you've got people who have struggled in the past with it, it might be worth considering whether or not to leave them on furlough. But what I wouldn't do is automatically leave those people on furlough, because that could be considered to be discriminatory. I'd be having a conversation with them about how you're doing. Is there anything we can do to help? Are you happy on coming back? Things like that, so that you can gauge whether or not they want to come back, and then you can make an informed decision. So how should we respond if an employee with no underlying health conditions does not want to come back to a workplace that is open because they're worried that it's not safe? So what we're tending to find is, if we've got a lot of employers who are dealing with this at the minute, where people are quite resistant to coming back. And they kind of fall into two camps, we've found. You've got the people who are just quite happy to sit on furlough because, yeah, they might only be getting 80%, but people aren't going out, people aren't going on holiday, so they can afford to sit there on 80%, and they basically just don't want to come back to work. They're quite happy to sit at home on furlough. And then you get the people who, even though they haven't got an underlying health condition, they may have got anxieties or depression, something like that, which is causing them to be super anxious about coming back to work. And, you know, those people obviously are going to be treated in a different way because there's different reasons for it. So you need to have a conversation with them really to get to the crux of why they don't want to come back. And then you can make a decision on how to deal with that individual person. So if the employee can work from home, which for you guys probably isn't going to be feasible given the nature of your businesses, but if you've got some people, maybe you've got bookkeepers or maybe you've got managers that do a lot of paperwork and things, it might be worth considering whether you can have them working from home, at least for part of the time. If the employee cannot work from home and they're not entitled to demand to work from home simply as a protective measure, although discrimination issues could arise in respect of employees in vulnerable groups. If an employee is concerned about the safety of the workplace, you may be able to reassure them by explaining the measures that you've put in place to protect their health and safety. And I mean, you really ought to be sending them your risk assessments, your COVID risk assessments anyway, regardless of whether or not they're anxious. If you've got people coming back, you should be letting them know what measures are in place before they return. And that might, you know, alleviate people's anxieties a little bit to understand exactly how you're keeping them safe. Flexibility about working hours is another way that you can minimise the number of employees in a building to help maintain the social distancing element. But fundamentally, if all of your measures are in place and these people simply just don't want to come back, you can look to discipline them for unauthorised absence. So it would be a case of removing them from furlough, saying you're back on Monday, you're back, you know, this is your next shift. And if they don't turn up, then, and they haven't got a good reason for not turning up, then it would be a disciplinary process that you would follow. Jason, I'm just going to throw to you really quickly. So Jason deals with a lot of our health and safety. Is there anything that you can suggest from a health and safety point of view that they might need to be considering when bringing people back?
Well, you mentioned it really in terms of the COVID-19 risk assessment. That's just absolutely crucial, and make sure you've got one in place. If you haven't got one as yet, and if you log onto the HSE website, the Health and Safety Executive website, there are templates on there that you can fill in. If you have done one, what I would do is just revisit it and check a couple of things on there. No slides on this. It's just if you've got pen and paper, I would just urge you to perhaps sort of make a few notes on this. So the COVID-19 risk assessment needs to have 4 things on it, really. One is what are the hazards? Second is who might be harmed. The third one is the severity of hazard. And the fourth one is the likelihood of the harm itself. They're the 4 areas that you should be addressing. And health and safety executive then also like to see that you've kind of given them a number ranking in terms of the hazards involved. So you kind of sort of do a bit of a sort of number from 1 to 5, 1 being a minor injury that really doesn't need any first aid or anything like that. It's just a really minor injury. 5 being a fatality. So go from 1 to 5 and just number rank the hazards in that order. And as Catherine's just said, third and final point really from your COVID-19 risk assessment is it's best practice to ensure that all staff have read it, and I would probably suggest to get them to sign to say they've read it as well. So from an employer's point of view, then you're completely covered. But certainly from a COVID-19 risk assessment, HSE website is the place to do it. There's templates on there, there's guidance on there as well. So that's really where you need to start.
I also believe there is a health and safety. I think you can get help through the BII as well if you need it. I'm not entirely sure where that is, but I'm sure if you got in touch with the membership team, they'd be able to help you with that. Okay. So that's the end of my kind of pre-planned questions and answers. So now I'm going to throw over to my lovely colleague Phoebe, who hopefully has been collecting all of the questions that have come through whilst I've been boring you, and she'll be able to answer. Hopefully.
There haven't been any so far in the chat box. So just give people a few minutes to see if they want to unmute and maybe ask some questions or pop some in.
I'll just say hello at this point if we've got no questions, and obviously that's the moment my doorbell rings. Bear with me 2 seconds.
Our life.
Sorry about that, everyone. That's just classic timing. For those of you who don't know, I'm Molly, so I'm Head of Communications for the BII. So thanks to everybody for joining the session today. Everybody obviously has covered lots of points in this session. If you need any help with any of the things raised, particularly risk assessments and kind of getting to grips with the guidance that has been issued over the last couple of days, head over to the website. If you remember, most of the information that you'll need will be a mixture of available freely on the website, but if there's anything you need from a helpline perspective, that's behind the member login. So if you've got any login issues, then pick up the phone to our team. I'll put some links in the chat as well, so you've got numbers, etc. But yeah, thanks so much to the guys for running the session today. I know it's a really confusing time for everybody from an employment law perspective.
Yeah, I mean, I'm confused at the best of times, if I'm honest, Molly, but, you know, this hasn't helped. All of this, having to sort of navigate our way through all of these trials and tribulations that the last year has thrown at us. And hopefully we've been able to support the members on the helpline as best we can. You know, at the start of it, there was a lot of, we can't give you a definitive answer on this, but this is our view, which was quite frustrating, because we do like to be able to give as much of a black and white answer as we possibly can. But, you know, it's not always feasible when when it's such an ever-moving feast as it was particularly at the start. So any questions come up, Phoebe?
Yeah, there's just been one from Simon, who has asked for some clarity about 2P. So he said that they're a company that take over leases on buildings, and he's looking for some clarity as to whether or not 2P would apply. I think it's hard to give a definitive answer because there's quite a few different variables. But as a general rule, if, you know, the primary function is going to be staying the same, then it's highly likely that it will. However, sometimes you can stop it from applying by, say, shutting for, you know, quite a long period of time. And if you weren't to open that business straight away, then you could potentially stop that transfer from happening. But I think as a general rule, most of the time 2P will apply. And it may make a difference that you are in Scotland as well. So I'd recommend probably just giving the BII helpline a call so we can talk about it in a bit more detail, because I'm not exactly sure what the parameters are within Scotland of the 2P legislation. And then there's just been a few more. So Wayne has said, do you recommend a particular contract for new employees post-COVID that offers a degree of security? I think what I'd recommend is try to avoid using a 0 hours contract unless it genuinely will be 0 hours and the hours of work will be quite sporadic. I think I'd probably recommend contracting them to a minimum number of hours a week or a month. So say 30 hours a month or 8 to 10 hours a week with a provision for overtime, so that you can still require them to work a certain number of shifts, but there's room for more. And yeah, you might just have to utilise the furlough scheme as well if there's a dip in trade.
Can I jump in on the end of that one, Phoebe? One has asked about specific advice about employing apprentices, I'll get my teeth in, or Kickstart employees. Really, if you are looking to employ new staff, those schemes are going to be really key and very helpful for you financially. We're pulling together some really kind of easily accessible advice for members around apprenticeships and Kickstart specifically. So we'll be releasing that next week or the week after. We have a sort of sister company called the BIIAB, who have recently joined forces with the Skills and Education Group, which is a huge awarding body with lots of resource and lots of help and advice. So we're accessing all of that at the moment. But they can help you to access everything that you need. But the trouble with it is that there's lots of kind of like, you could have an apprentice or you could do Kickstart, and then you have to kind of sign up to get more information. So we're pulling together a bit more general information for those who don't necessarily want to leap in but want to find out more before they do.
If I could just add something to that then, Molly, if you don't mind.
Yeah.
When it comes to those different initiatives, it's really important to ensure that you get the correct contract. So for instance, if they are an apprentice, you need to have an apprentice agreement. Otherwise, you can get yourself into hot water, particularly if you want to terminate them. If you haven't got the proper contract in place to govern that relationship, if you try and terminate an apprentice, then you can sometimes get yourself in a position where you've almost agreed a fixed term, and so you might have to pay the remainder of that the sort of the period of time that you'd agreed to take them on. And there's quite a few pitfalls that you can fall into. So it's really important to get the right agreement governing particular like different relationships. And also on the back of what Phoebe said, we're not really recommending that you need anything particular in contracts to deal with COVID, because COVID's so unique. But not only is it unique, but also something else could happen next year. Let's all hope it doesn't, but you never know, so it's more about having general clauses, not specific clauses. And I think for us, the one that we found a lot of people didn't have, and that's just because we've not really needed to have these clauses in place for a while, is the layoff and short time working clauses, because that gives you the sort of the ability as an employer to put people on short time working or indeed lay them off, and it gives you the legal right to do that. And we found that a lot of people, because they didn't have that clause in there, it meant that they were struggling to implement furlough. So it's important to look at that clause. Would you agree, Phoebe?
Yeah, definitely.
Yeah. Sorry to have interrupted.
No. I'll just go through a few more questions. So Dawn has asked if, when she takes on new staff, is it okay to just pay them 80% if she was paying 100% to existing staff before? And yes, that would be absolutely fine. The only way that it would be discrimination would be if the reason for you only paying certain people 80% was because of a protected characteristic, so race or disability or something like that. But no, there won't be an issue with that, provided they are actually eligible for furlough. So I just check on that. And then
can I just add something to
yeah
that? I think also, Dawn, an interesting scenario would be where you have to furlough your current furloughed staff in the future if things don't get back to normal. And I think that if you then wanted to drop them to 80% subject to what the scheme says at the time, that wouldn't be discriminatory either. So, you know, don't feel that you'd have to keep your existing staff who've got 100%, because I don't think it would be a contractual term. I don't know what the HR team think. I would think it's okay.
Yeah,
you know, to do what's right.
It's fine.
Yeah.
Or even if you did have it specifically within your furlough agreement, just issue a new agreement.
Yeah, definitely.
Yeah.
I think it's purely discretionary whether or not you pay them 100%. And yeah, like Kat says, I mean, I would just issue a new agreement or just issue a letter of amendment to that.
Yeah.
The next one is, if we are taking on new casual staff, what contracts should we be putting them on? If they're going to be genuinely casual, so, you know, kind of sporadic hours here and there, you know, not working very often for you, then I put them on a 0 hours contract. And there's nothing wrong with doing that. But if they are going to be working for you every week, I wouldn't put them on a 0 hours contract, because it just won't be worth the paper it's written on in a few months' time if it doesn't actually reflect what the arrangement is. So like I said before, I'd use the BII contract builder. And when it comes to putting in what the hours of work are going to be, I just put a really low number. So 1 shift a week, 2 shifts a week, something like that. And you can always consult with them to reduce or increase that number as time goes on. And that's a much better way of going about it than just putting them on a 0 hours contract, to be honest. The next one from Alan says, if I have an employee stating I can't email them as it is regarded work, how am I expected to communicate with them about their return? So you absolutely can email them about their return. There's nothing wrong with doing that. I wouldn't worry at all. I would just try to keep communication to a minimum, obviously, but as long as it is about returning to work, then that's absolutely fine. I'd go back to them and say, no, it's about your return to work. It isn't work. And you're okay to do that, in my opinion.
I think I would add to that as well. Before I did this, I used to run pubs and restaurants, and I employed quite a large number of people. And so from running a business point of view, I think if I'd got an employee who was being like that, and I had to, and sort of obviously being a bit finicky and a bit resistant, and probably that one is probably one that's wanting to stay on furlough, no doubt as well. I'd be thinking about moving forward, if you are having to reduce, you know, headcount, I'd be thinking about the people who are working with you and being cooperative during furlough and worrying about your business, and also about the people who are maybe being a bit resistant to you. And don't forget that.
Yeah, I completely agree.
Yeah.
So the next one is from Elizabeth, who said, if you are taking over an existing business premises, but your new business idea is completely different, would 2P apply? If it's a completely different business altogether, then no, as a general rule. But if some of the services are going to be the same, then I think it is risky, to be honest, to assume that it automatically wouldn't apply. And I definitely think you should take advice. And you can call the BII helpline to talk a bit more about the specific situation and get some more guidance. But it's hard to say for definite, because it depends on a variety of things. But if the business is going to be completely different, then no, like I said, but I would take advice on that, to be honest. If you give us a call, we can talk to you about it a bit more.
And when we're talking about different, you're talking about completely different, aren't you? Do you remember a while ago we had that lady who phoned up and she said that she was just going to stop, I think she was going to stop serving like British food in the pub, and she was going to start serving curry instead. And so because that was completely different, the 2P wouldn't apply. And it's like, well, no, because it's fundamentally the same offering, it's just a different cuisine. Yeah. So it needs to be substantially different for 2P not to apply.
I think even in the situation of you know, it previously being a restaurant and now just been turned into a bar, I still think that 2P would apply to that, to be honest, to some degree.
Yeah, and you'd just make the kitchen staff redundant.
Yeah, and keep the rest of them on.
Yeah.
So you just have to take it on a case by case with that, unfortunately. The next one from Wayne says, is the short time working clause now in the BII template? I believe it is.
I believe it is too.
I'm pretty sure it always has been somewhere. It may have been moved, but I'd be very surprised if it isn't.
I think we did double check it right when all the pandemic started kicking off, didn't we, Phoebe? I think we did to double check that it was. Yeah.
I'm 99% it will be in there, but we can check that just to make sure. And that's all the questions at the minute. If anyone's got any more, then just pop them on now. But yeah, that's everything.
So thank you very much for that feedback.
I was going to say, Catherine and the team, can I just say thank you? It's the first webinar I've been able to dial in through the BII, and obviously Molly being with us. And it's just great to hear some of the questions you know, future operators are thinking about now. So that's going to be really useful. I've made plenty of notes and taken some screenshots. So yeah, thank you to all of you.
But obviously, you know, we can only give general advice. Every situation is different. You know, there are always lots of shades of grey within any different scenario. So at any point you're not sure about anything, that's what the BII helpline is for. Give us a call. There's always somebody at the end of a phone. You know, we try and share it out between us all as much as possible. So it's not always the same person that you're going to get, but we will always give you consistent and pragmatic advice.
There's just been one more question quickly from Alan, who said he hasn't got a contract in place for an employee. So it's either been removed by them or from the office. Can he issue a new contract? I would say, yeah, absolutely. Just issue a new one. As long as the fundamental terms remain the same, I would just ask them to sign a new contract. But make sure that you date it from the start of their employment, because all the continuous service will remain in place. So just make sure that you date it from the date that they started with you and not a new date. But I would just reissue a contract. Yes, can't see an issue with that.
Okay, so I think we'll hand back to Jay to say goodbye.
Yeah, well, thank you so much, Catherine and Phoebe. I think it is invaluable for BII members, particularly at the moment, to have all this information, and we really wanted to pitch this very much as a question and answer rather than, you know, as a law firm we are used to doing very formal presentations, but what we're finding at the moment is people want just, you know, really practical answers to the questions that are currently coming up. So, you know, I think these sessions are really valuable. So just so you know, we've got the next one on the 7th of April. Have we added in a new date then, the 19th of April?
I think the suggestion was for a new date. I haven't done that 100%.
But I think we've added in possibly a new date. I think we did, because we thought, well, let's, you know, after the 12th, some of you guys are going to have other questions, aren't you? And we'll be dealing with lots of new questions coming in. So let's share that, you know, with whoever's on the call, because you can all learn from each other, as well as, you know, us sharing our knowledge. If there's anything that hasn't been covered, you can contact us. I'd say, first of all, go through the BII helpline. We'll see if we can help you on that. Obviously, there are some matters that you need, you know, most businesses will need some additional support with HR and employment law. We can, you know, certainly help you with that. We have preferential rates for BII members. But, you know, I'd always say start with the BII helpline, because you're already getting that as a free